some of these laws, and I realize there's a lot to digest, and we're going to try to cover as much as we can in an hour session, and then try to even less than that, and try to get some questions answered as well. All right, Kate, if you want to hit, you got the slide, I think. All right, so obviously we're all familiar with the familiar, that's a loose term, but we know about the Families First Coronavirus Response Act that was passed and signed into law last week. And there's been a lot of questions about that. And there's been, just so you know, there's new guidance that came out last night. And I say guidance, you go to the Department of Labor website, they have yet another question and answer. We were just reviewing it, and literally we just got our hands on it a little bit ago. So I haven't read it all, nor has Kate, but we've read a bunch of it. That actually is very helpful. So I know they had a question and answer one that came out a couple days ago. This is a new one, and I would absolutely suggest you look that over. It does answer a lot of questions. And I think even though we have regulations that are going to come out in the next week, we're hearing early April. I think this question and answer that came out last night or this morning was very helpful. So the law effectively has got two types of paid leave. One is the emergency paid sick leave, which I'm going to talk a little bit about, and then Kate's going to talk about the Extended Family Medical Leave Act paid leave that they've got as well. And we'll go ahead, Kate, if you want to hit the next slide here. So let me talk a little bit about the emergency paid leave. So as you all know, originally it said April 2nd was the date that this was all going to be due to start, but it's actually now been pushed back April 1st. And then it expires, at least currently, December 31st, 2020. And it covers employers, including any public or private employer with fewer than 500 people. And again, I'm just going to emphasize this emergency paid sick leave is just the one that deals with 2 weeks of pay. The eligible employees are all employees. There's no waiting requirement for any of these laws, unlike where we had situations you're familiar with, FMLA, and having somebody work there for 12 months at 1,250 hours. All that has been tabled pretty much. If they've been there 30 days, they're going to be eligible, and that's from March 2nd forward. Okay, we'll hit the next one here. So this is where we've struggled as lawyers advising our clients, and I'm just going to do this a little bit hypothetically before I hit the 6 qualifying reasons. We have received a number of questions from factories, from restaurants, from hotels. Okay, we laid off our people. Does that mean we have to, whether they furloughed them or we've laid them off or we've terminated them, do we have to pay them automatically under this law? And the answer, we believe now, given the most recent question and answer, is no, you don't, unless they qualify for one of these 6 reasons. Okay, and so the 6 qualifying reasons, and the one that's been hung up on is number 1, and I'll get to that in a second. But so you look at these 6 reasons as to whether or not they're going to get the 2 weeks of emergency medical pay, and then a couple of these qualifying reasons Kate's going to be addressing as it relates to extended FMLA leave and pay. So the number 1 kind of hang up here was number 1, subject to a quarantine or isolation order related to COVID-19. And I realize there are people listening to this in different states, and obviously we're sitting here in Virginia, so I can only really speak directly to Virginia and federal law. But you may well have certain circumstances within your own state that could expand rights. Yeah, as you all know, federal law trumps, but state law can expand. It can never reduce a federal law. It can only expand it. Okay, number 1 is subject to a quarantine or isolation order related to COVID-19. The whole issue there being, okay, well, so if somebody's just out, I lay them off or I furlough them and they're out, and the reason I shut down is because the governor of my state said, hey, you can't be open, or you can't, for different reasons, that is shut my operation down. Do I have to pay them? What we are getting out of the guidance and question so far is no, you do not, unless they qualify. In other words, the employee has been isolated or quarantined, not the employer. So if the employer has been shut down by an order, that's a different situation. So the focus on this law appears to be from the employee's perspective. Have they been quarantined or issued an isolation order related to COVID-19. Number 2 is, have they been advised by a healthcare provider to self-quarantine? Then they would qualify. Number 3, are they experiencing symptoms of COVID-19 and seeking medical diagnosis? Again, that's a little wishy-washy. I had questions this morning from a client that said, okay, we had somebody who we took their temperature, it was over 100.4, and what do we do now with that person? Do we shut down the plant? Do we have to? Do we send them home? We can talk a little bit more about that. But again, experiencing symptoms. And some of the question answers that came from the Department of Labor also give us better guidance on what documentation you can request from an employee. I don't have time to get into all that, but again, I would refer you to that question and answer. You are entitled to seek information, to have an employee provide you a basis for why they qualify for one of these 6 reasons. Number 4 is obviously caring for an individual, subject, or advised to quarantine or isolation. And that is one that's going to trigger some other issues that Cate will probably address here in a moment. And then caring for a minor child whose school or place of childcare or childcare provider is unavailable due to COVID-19 precautions. And then finally, experiencing similar conditions as specified in consultation with the Labor and Treasury. So if we want to go, unless Cate, do you have anything on that one you want to share?
Not in addition to what you've said. I think we'll talk a little bit more about the FMLA, but I do think it's interesting that we just got the guidance on number 1 literally last night, and that's been the main question, because a lot of states, whether a company is deemed essential or non-essential has become a big deal. And so if you have a company that is deemed non-essential and then has to lay people off because they don't have enough business to continue, then is that person going to be subjected to that paid sick leave? And the answer now, we've learned just a few hours ago, is no. So it's good to have that answer.
All right, thanks. All right, so protections. Employers cannot require an employee to use other accrued leave first. So you can't, under normal FMLA circumstances and just normal leave of absences, a lot of times you can require that, not under this law. Existing leave policies cannot be changed to incorporate a credit or reduction of benefits against the employee's existing leave entitlement. Likewise, employers cannot obviously retaliate against an employee who uses or seeks to use this leave. And that's really kind of one of the big, if you want to call it, litigation opportunities in this law, where if somebody were retaliating. So you've got to be careful about laying off employees prior to April 1 in order to get out of paying this leave. And again, the new question and answers that are provided today from the Department of Labor answer a number of these questions about what happens if, I have somebody on leave before this law goes in effect and what happens after that. And so that'll help you a little bit. I guess we can go to the next slide. All right, so how much pay is required? Basically, this is the emergency pay leave. It's effectively, it's a 2-week pay, and it's up to 80 hours at full regular pay if out due to their, own health problem. Now, when you kick it into the other one, which will also trigger potentially the FMLA extension, when caring for another, then items 4, 5, and 6, which are up above, then the paid sick leave is at 2/3 the employee's regular rate. And then part-time employees, number of hours is calculated based on the average number of hours the employees worked per week over the last 6-month period. There are caps on the benefits, as you probably have heard. The maximum benefit for an employee missing time for his own health, which are qualifying reasons 1, 2, and 3, is $511 a day for up to 10 days, again, 2 weeks, 2 calendar weeks. So then, but when leave is taken to care for others, which is 4, 5, and 6 above, the rate is $200 a day, the cap. All right, let's see here what we got next. Okay, I'm now going to turn it over to Cate and let her talk a little bit about this.
All right, so in addition to the paid sick leave, there is a new expanded emergency FMLA leave provision that has been passed. It is effective just like the paid sick leave, April 1st. It expires December 31st, 2020. So even if somebody goes out on this emergency FMLA leave on December 1, it's going to expire December 31st, even if they would have potentially had a couple of more weeks left. So this is the kind of critical part of this. Any business with fewer than 500 employees are going to be affected by this. So we're not looking at businesses that have 50 or more people within a 75-mile radius, or employees who have worked 1,250 hours. These are not the typical qualifying conditions that we have generally, because this is an emergency FMLA leave. So there is going to be an exemption process. If an employer has 50 or fewer employees, they will be eligible to at least apply for some type of exemption from the paid sick leave or from the emergency FMLA leave. Unfortunately, we do not have any guidance on that yet, or any regulations interpreting what it's going to take for an employer to apply for that exemption. I have no doubt that there will be a lot of companies, especially very, very small employers, who will meet the requirements for that exemption. On the flip side, though, I also know that there are going to be a lot of employers who have just shy of 50 employees who probably won't qualify for the exemption. So it's not going to apply to everybody. And again, we just don't know what the requirements for that are going to be. Eligible employees only have to be working on your payroll for 30 days. So again, not the 1,250-hour requirement, 30 days, and have a qualifying need. Again, if you're taking FMLA for your own illness, so something that, whether it's maternity leave, or if you're on FMLA leave for another serious health condition that's unrelated to caring for a child or someone whose daycare or school is closed, and we'll talk about that in a minute, that's going to go back under regular FMLA leave. You're still going to have the 1,250-hour requirement, 50 or more employees within a 75-mile radius. All of the FMLA requirements with which you're already familiar will apply to that. All right. So the only qualifying need, this is really important because we've gotten a lot of questions from clients this past week about, okay, well, if I am home with symptoms of COVID-19, can I get the paid sick leave and then also get this emergency FMLA? No, you can't. The only qualifying need under the emergency expanded FMLA is that the employee is unable to work because a child or someone else, maybe an elderly parent, who's in a care facility, those facilities have been closed or shut down, schools, daycares, things like that, due to COVID-19. Now, the act says a public health emergency, but specifically right now we're talking about COVID-19. That is the only qualifying need. If somebody wants to take more than the 2 weeks paid sick leave and try to have any COVID-19 related illness qualify under regular FMLA, we're still not sure whether that's going to constitute the requisite serious health condition so that a person could actually get that FMLA leave. We don't have guidance on that yet. All we know is right now, this expanded FMLA leave is to care for a child who's not in school or can't be at a daycare facility. How much pay is required? So interestingly, and I'm not sure why they did this exactly, but the first 10 days, so basically 2 weeks of work, 2 5-day weeks, are unpaid under this expanded FMLA, which is kind of funny because they can take their paid sick leave and get paid for that time anyway. But the first 10 days of this emergency FMLA are unpaid. The last 10 weeks are paid at 2/3 of the employee's regular rate of pay, with a maximum benefit of $200 per day. And again, just understand that if you have this FMLA leave for, say, a month, and then the schools reopen or daycare center reopens and the child can go back, or you have other childcare, you lose the ability to have that emergency FMLA. And if it looks like I'm turning away and reading from a computer, it's because I am, because we have the new guidance pulled up on another screen. So I can tell you that today, as part of the new guidance that was issued, they do say that employers can require paperwork from the employee, whether it be for the paid sick leave or for the FMLA leave. Trying to scroll where it is. Okay, so you have to provide your employer documentation in support of the fact that you need the expanded family and medical leave. You don't just get to take it and say you need it, and the employer just has to trust what you say. You do have to provide that documentation about the school or place of care being closed, something showing that you are the primary caregiver, something like that. And the employer's got to retain that notice or documentation in support of the expanded family and medical leave. So keeping that documentation, making sure you have the documentation you need is going to be really important in this as well. Okay, restoration to position. As you all know, when we're dealing with regular FMLA, we talk about kind of the elevator. If somebody gets off on the 7th floor and takes FMLA leave, they get to get right back on at the 7th floor, return to an equal, same or equivalent position. They have that right under FMLA. Now, emergency FMLA is job protected as well. But if you have 25 or fewer employees, there's a potential exception for that if for some reason the position no longer exists. You as the employer just have to take reasonable efforts to contact the employee for up to a year if a position does become available. So this new paid sick leave and expanded FMLA leave, they are not meant to just completely burden a small business. Now, in certain situations, they're not going to be great for small businesses, but there are some things in place to try to ease the burden a little bit while also providing some benefits to employees as well. The new guidance that we got last night talks a little bit more about how to determine the 500 employee count. The regulations we hope to get in early April. They were promised to us, well, they told us they might get them to us by Wednesday. We didn't get those. So we're going to look for them in early April. We'll set out specific requirements, one for how to calculate that 500 employee to know if you are exempt from participating in the paid sick leave and emergency FMLA. And it's also going to set forth the process for which to apply the exemption for employers with under 50 employees. Again, I think some folks are going to get this exemption. Other small businesses probably won't. We do know that whatever requirements are put in place to get that exemption, you have to be able to show that paying the paid sick leave, paying the emergency FMLA would jeopardize the viability of the business. What that means exactly, we hope to get in the regulations. So what's also interesting about the emergency FMLA is with your typical FMLA case, you can sue for back pay, you can sue for a number of different types of damages, attorney's fees, liquidated damages, back pay. With this new emergency FMLA, if somebody is suing for retaliation under that, all they can get is just regular retaliation type damages. They can't get back pay, they can't get liquidated damages. It's going to be a different type of recovery if they can successfully prove retaliation. There is going to be, for both the paid sick leave and for the emergency FMLA leave, a refundable tax credit that will be provided for these leave payments made to employees under the new law. There's also a credit for the employer's portion of the Social Security taxes. Again, how that's going to work in practice, we won't know until we have the regulations interpreting the new law. Again, I'm harping on this because I'm annoyed that they keep passing laws and giving us absolutely no interpretive regulations. But we do have the guidance. We do have a little bit more guidance about how the paid sick leave and expanded emergency FMLA play together, which is really important. So if you have an employee who is home with a child and the school is closed, then obviously you're going to potentially qualify for that emergency FMLA leave. You could also potentially get the initial 2 weeks paid leave under the paid sick leave, and then get the 2/3 of your regular rate of pay for the remaining 10 weeks for the FMLA. Because I believe it was number 4 or 5, without going back on the slides, of circumstances where an employee can get that paid sick leave, and caring for a child or family member is one of those things. So that's kind of how they've said this is going to play together. I don't know, many of you are probably already familiar with this, but this week the Department of Labor came out with some posters that every employer 500 or under is going to be required to post in a conspicuous place in your work site. So if you say you're a construction company, you have multiple work sites, you have a trailer folks can go, you have an office they go to in the morning, you have a break room area, wherever employees are going to go where they can all be sure to see these posters is where they have to be posted. This is the website here for those posters. Just print them off. It's free to get them. You can also contact the Department of Labor. I'm sure they can mail them to you, but the easiest thing to do it quickly is to go on the site and print them off. You have to make sure that it is in a place where all employees can see it. There has been a little bit of guidance that if there is not going to be one singular place for the posters to go, then you may have to end up emailing them or somehow otherwise distributing them to employees so they can be sure that they understand the requirements. All right, back to Paul.
All right, I'm back on. Okay. All right. So another area that we're obviously dealing with different issues is just workplace prevention and response. And like Kate, I may be looking at another screen as well because I've got some different documents that we've been dealing, or just different information we've been dealing with. But obviously this comes down to communication. And when I'm talking about workplace prevention response, depending on where you're listening to this webinar from, your community may be far more impacted than other ones. And so, some of this is really hits home where you are actually having people test positive in the workplace or in your community. And really, obviously, one size does not fit all. You've got to be sure you're in communication if you've got subcontractors, vendors, suppliers, and others who are present on your work site. I mean, this is largely a communication situation where you're entitled to get information. I mean, where the law kind of intersects with this deals with whether you've got Americans with Disabilities Act issues or HIPAA issues, but this is something where you have the right to get information, or certainly you have the right to be asking. Whether you'll get it is another matter, but you have the right to certainly find out if somebody has tested positive, or whether if somebody is on your workplace, and whether you're going to be preventing them from coming onto your workplace, depending on what information you get. Kate, anything else on that one you want to share?
No, I think you've covered it.
Okay. All right. We'll go to the next one here if we could. All right. Another area, again, these are questions we're getting, is dealing with cleanliness and who, what, when, and where, and how do we have what are we going to do in a response? We have a number of companies that are actually putting together for their management team a kind of response memo, if you will, a proactive type memo where they are saying, okay, if you find out somebody has tested positive, what are we going to do? What is going to be the protocols that we are going to employ for dealing with this? This could also deal with if you're in a manufacturing environment or not. How are we going to have it? Are we going to have it professionally cleaned? Is there even anybody who's going to be willing to do it? And then there's just the day-to-day cleanliness. We have a lot of companies that are literally going through there almost by the hour, making sure employees understand how to clean workstations, areas that they're at, or having somebody come in there and doing that. It's all about, looking at what you are doing to be reasonable. And it's so much of this, I was, again, on the phone, I keep on saying that, but I'm on the phone all the time. And a lot of this is not necessarily legal answers. They're PR questions. There's situations where you're looking at how am I going to appear to my customers and to my clients and just the overall workforce, the employees I care so much about. What am I doing? What steps am I taking? And how am I training people to take the steps? I do think these protocols could be very important, particularly if you're in a community that either you think may have a significant uptick in issues of how you're going to deal with it when and if you have somebody test positive. What are you going to do? What steps are you going to take? How are you going to get information? And I think that is covered a little bit more on the next slide, if I'm correct here. Yeah, so, but before I'll address that, we've had a number of situations where clients are trying to really manage not only just the work site in terms of preventing any kind of outbreak, but also just dealing with the financial considerations, alternating shifts, having everybody work remotely, having physical separation. It all ultimately obviously works out to what works best for your workplace. But we have had clients that have alternating shifts, are working 1 week on, 1 week off. And then you get into wage and hour issues, which we can address here in a little bit, but that is certainly something you can do. The employees can in most states can apply for temporary unemployment. And certainly we've seen some of the federal legislation that's come down on that with the CARES Act, which we'll be talking about in a little bit here.
I'm going to add one thing to that as well. What's going to be really important, since I know a lot of you all work in different industries, different types of companies, you got to really think about the footprint of your employees. Are they being transported to a work site in a van, for instance? Maybe take fewer employees at once. Maybe if there's a way to stagger break time, If employees are sharing tools, give them the opportunity to wipe those tools down. Let them know that you understand the need for cleanliness, give them the time to do that. There are different ways to just think this through depending upon the type of business you're in. If people are using the same equipment, wipe down the control panels, just think it through, because again, one size isn't going to fit all. And we're not all entirely sure how to handle this because it's new. So everybody's doing their best, and it's going to require everybody to really be thoughtful and put a plan into place, and then change the plan as needed.
Okay, so, all right, this gets back to, and we get, again, these are questions that we've had a number of times. Yes, you can certainly send an employee home if they're exhibiting symptoms of COVID-19, even without a positive test. Again, the issue that we're seeing more is, okay, well, if I've done that, what do I have to do with the rest of my employees? What do I have to tell them? How am I going to react? How am I going to communicate with them? And you have to be aware of that you do have HIPAA issues. And generally, you should not be identifying the employee who's tested positive or is exhibiting symptoms. But as Cate was just saying, you want to find out kind of the footprint of that employee. I was talking to a company this morning, and I said, well, they had somebody that had the fever, and there's concern in senior management, this person has tested positive or will test positive. What do we do? And actually, that was a situation in which this person came in from a staffing company. So it was not our manufacturing facilities employee, but it was a temporary employee. And so then the communication there was, okay, how are we going to get more information? We would like to know what if that employee is going to go to a doctor, are they going to get tested? Because that's going to impact our response. And the other part of that was, as I told them, is you cannot make the employee go get tested. You can keep the employee or worker out of your work site, but that doesn't exactly help you if you don't know whether that person's tested positive. Hopefully they would take the steps to get it done, and you can talk to if it's a situation where that's not your employee, but a worker's come on your site, you could then have that person, encourage their employer actually to go and have them tested. But then it gets back to, okay, well, what do we do? Some companies are being more aggressive than others. If that person tests positive, then they're removing everybody that was in their workspace, sometimes shutting down that line or that area, getting it cleaned and putting everybody who was in that person's footprint gone for 14 days until we figure it out. Because again, that person could have been asymptomatic and already been spreading it prior to. So these are all circumstances you have to kind of evaluate. That's why I think it would be important to at least have some protocols in place of how you're going to handle this. If you think somebody is tested positive or is going to test positive or actually has, how are you going to react? What's going to be the plan going forward? Cate, anything more on your end on that?
No, not on my end, thanks.
Okay, so again, it's a reaction to this, how you communicate it, and what's going to be the follow-up. Because other employees obviously there's always a freak out factor with something like this, and we're all kind of, as Cate said, we're all dealing with something very new. But I do think reassuring everybody that you are taking the steps and you have a plan in place, that alleviates a lot of the anxiety. I mean, I think companies want to know, or employees want to know, that there is something in place. It's not just we're just going to fly completely by the seat of our pants, but sometimes in this circumstances, there is a bit of flying a little bit, without, having everything in place. But I think having something in place is a huge step. All right, what's next? I think that's you, Cate.
All right, so there are certain reporting requirements if you have somebody who has tested positive, but under the Virginia Department of Health, you do not have a duty as an employer to report anything to the Virginia Department of Health. That is incumbent upon the healthcare provider. If they've got someone they're treating who has tested positive for COVID-19, you as the employer do not have to do that. Under OSHA, this is going to be really important. So of course, OSHA right now is issuing a lot of guidance. They're issuing guidance regarding personal protective equipment, if you can find any to buy, guidance on the general duty clause, saying you have, as an employer, a duty to keep the workplace safe as best you can. However, right now, what OSHA is saying is that COVID-19 is defined under their illness definition, and it has to be recorded if an employee gets it in the workplace, if it is work related. And what we're finding is that a lot of employers are over-reporting because they have someone with symptoms, or they have somebody with a temperature, or they've sent somebody out for testing. Be really careful doing that, because that's going to skew your rating as an employer. Make sure you understand if there is some kind of work-related reason that a person has tested positive for COVID-19 before you report it to OSHA. What we're seeing right now is, because it's going to be really hard for folks to prove that something was contracted in the workplace, OSHA has taken the role of just more educational, helping people understand personal protective equipment, understanding how to keep the workplace safe, how to clean, things like that. There's a lot of really good resources on the OSHA website about how to professionally clean and sterilize your workplace. I'd encourage all of you to take a look at that. Let's talk a little bit about workers' comp. So if any of you, and again, this is going to be tailored more toward Virginia, though I think the kind of general principles will cross over into other states as well. But in Virginia, for an employee to have a compensable injury by accident has to both arise out of the employment and be in the course of employment. And the course of employment is going to mean, it happens on the clock, on the premises, that type of thing. And it is far easier for the employee to prove. Arising out of is a different situation. And that's where the coronavirus comes in. The employee has to prove that whatever the occupational disease is, in this case coronavirus, is somehow a risk of the workplace. But for some aspect of the job, of the workplace, this person would not have been exposed to coronavirus. So in Virginia workers' comp, coronavirus is going to be considered to be an ordinary disease of life. And what that means is you can catch it outside of the workplace. That's probably where you would catch it. To prove something like this, a claimant or employee is going to have to prove by clear and convincing evidence that the exposure occurred in the workplace. And that's going to be really tough to do, especially when someone can go and contract it at the grocery store, running outside if someone coughs in their general direction, if they've traveled. So it's going to be really hard to prove if something has actually arisen out of some kind of contact within the workplace. Now, if you're an employer, understand that if you get these claims, even if you win ultimately, you still need to walk it through the same claims process as you would for any other occupational disease or alleged work accident. You got to make sure you report it properly to your carrier, do the first report of injury to the commission, everything you would normally do for a regular workers' compensation claim, you need to do it here to make sure you don't lose whatever coverage you may have. All right, going to go back to Paul a little bit. We'll talk a little bit more about one other aspect of workers' comp as it relates to layoffs in a minute.
Thanks, Kate. All right, so wage and hour issues, as you all know, and I could take all day long talk about wage and hour issues, but every employee, unless they're an owner, has to be classified as either exempt or non-exempt. And if you want to think of it in terms of hourly or salaried, we don't as employment lawyers, because you can certainly have somebody who is non-exempt who is paid a salary. But be that as it may, for non-exempt employees, ones that are entitled to receive overtime, you can absolutely send somebody, if they're not working, they don't have to be paid. All right. Now, that's all subject to, if they qualify for some other reasons that we talked about under the emergency leave or FMLA. I'm not talking about those issues, but I'm just talking about somebody who is not working. Don't have to be paid. And if they're not performing compensable work, then the wages due, and then you have on-call time, so that gets into, okay, well, you're not really working, but you're kind of working, you're engaged to wait to work, and as opposed to being, waiting to engage. So if you are already got that person who can't really do much of anything other than listen to your next command, then they're obviously on call. I mean, there's a lot of litigation over that, and I won't get into all that, but you just have to look at, is somebody answering emails? Is somebody taking phone calls? Are they still working? And if they're working and they're non-exempt, they got to be paid for the hours and time that they worked. All right. And then the next one is, so then you have exempt employees. So generally you're salaried employees, but again, you can have salaried, non-exempt. But this one's a little trickier. And I want to talk about this for just a moment, particularly with furlough situations. So if you've got somebody who is exempt, a salaried employee, and you've got them doing some work, partial work in a week, they've got to be paid their full salary. So if they work one day out of that week, there's some exceptions, but generally under federal law, for an exempt employee, if they're checking email, answering work-related phone calls, they're going to be, and they're considered otherwise exempt. If they work part of that week, any part of that week, they got to be paid the full week. Otherwise, you're going to lose the exemption, and then they will no longer be exempt. And so that's a problem. So if you've got an exempt employee who's quarantined for a complete work week and performs no work in that week, then no compensation is necessary. And again, you can reduce salary for these individuals as long as it's $684 a week. You can still, maintain that exemption. I did have an issue yesterday where an employer was basically had reduced his salaried workforce by 20%. So the salaries of the employees was being reduced by 20%. But what he told them kind of as an aside was, hey, but you only need to work 4 days. I'm going to pay you that, but just work 4 days. And I told him, I don't think that's a good way to go, because you're effectively, what you're doing is now you're having them work just 4 days and you're paying them for only 4 days. I would much rather have it be where if somebody just reduced their salary by 20% and say, no matter what you work in that given week, if you work 1 day, 3 days, 5 days, this is your new salary. That's the way it should, that would be the better way to go about that, to maintain the exemption. All right, what's the next slide here? Okay, furloughs. So I knew we would hear a lot about furloughs and what's the difference between a furlough and a layoff. Basically a furlough is reducing the number of days or hours an employee can work, whereas a layoff is more like a temporary or permanent termination. I mean, people, honestly, the law doesn't look at layoff and termination very differently. It's ultimately what you relay to the employee as to whether they're going to come back. When they're furloughed, a lot of times you do that for seasonal things, but now we're doing it because of COVID-19. So you're going to reduce the number of days or hours they're working. And do you have to pay these employees? No, if they're furloughed, you don't, except that's with non-exempt employees. Exempt employees, again, same thing. Even if they're furloughed, if they're doing any work during that particular work week, they're going to have to be paid for the full week. Health insurance, you're going to want to consult your brokers or your healthcare plans, but generally, as a furloughed employee or somebody who's still an employee, they're still going to be covered under your healthcare plan. You're not going to necessarily trigger COBRA, and they still have to pay their employees' share unless you're going to cover that for them. So this is something that is obviously plan specific, but overall, it operates just like a general leave of absence where the employee is still covered under the plan. All right, we have next here.
I'm going to add one thing to that. So as part of the new guidance that we got this morning from the Department of Labor, they specifically have stated if your employer is open, so companies still operating even with a skeleton crew, and you are furloughed on or after April 1st, which is the date that paid sick leave and the emergency FMLA leave can kick in, then the question was, can the employee receive paid sick leave or expanded family and medical leave? Because, hey, the company is not working as many employees because of the COVID-19. Well, the answer to that is no. If your employer furloughs you because it does not have enough work for you to do, reduces your hours, your remedy for employees through that is going to be unemployment compensation. It's not going to be the paid sick leave or emergency FMLA. So we just got that answer this morning. So let's talk a little bit about shutting down operations. If you're a larger employee, this isn't going to apply as much to the smaller employees, but if you're a larger employee, you need to consider the WARN Act, which is basically a 60-day notice requirement, among other things, that you have to give employees if you are shutting down 30% of your workforce, or in some cases 50 employees. It depends upon the number of employees you have. There is an exception to this notice requirement for natural disasters or unforeseen business circumstances. Now, again, because this COVID-19 stuff is new, it has not been defined officially as a natural disaster, but we are going to see employers trying to use the exception for an unforeseen business circumstance. What it requires there is simply that you provide notice as soon as you can to employees that there's going to be a mass layoff, and give the reason why you could not give the 60-day notice requirement. Let's talk a little bit more about workers' comp. If a company has an economic downturn, has an unforeseen business circumstance like the COVID-19, and has to lay people off, what do you do with an employee who is working light duty, who is not totally disabled, but who is partially disabled? Do you have to then kick in and pay that employee total disability because they are on workers' comp? The answer to that is no, under the economic loss rule. So if a claimant's loss of employment has nothing to do with the fact that he or she is on light duty, or the fact that he or she has some partial disability, has been moved to another position because of that disability, then you're not going to be required to pay them total disability benefits. If a coworker who is not disabled is suffering basically the same economic fate, also laid off, also has a reduction in hours, reduction in pay, then you're not going to have to pay that person or pay the disabled employee workers' comp for that time period. Now, this is a very narrow test, and it's only in Virginia. I don't know what other states are going to say about this. It's a very narrow test. So if the employee can come in and prove, well, but for my you only let go this one category of workers, and but for my disability, I wouldn't even be working in that job because otherwise I wouldn't be on light duty, then that person's going to probably have a better case for benefits. But if you as the employer can show, look, we had to let a bunch of people go, disabled, not disabled, because of an unforeseen circumstance or because of something that's affecting the company as a whole, that person is probably not going to be able to continue to receive disability benefits for that period of time. So if you're seeing any of that, talk to your carrier about that, try to work through some of those issues. Happy to provide some additional resources on that if you need. Talk a little bit about unemployment compensation. So two days ago, I'm losing track of time, the Senate passed the CARES Act. Like Paul told you earlier, we expect the House is going to pass it within an hour or two, and then it will be signed into law as early as I think President Trump has said Monday, maybe sooner if the House can vote on it sooner. But one of the aspects of this 800-page CARES Act deals with additional unemployment compensation for employees who do lose work, do lose hours, cannot work because of COVID-related reasons. There's a number of different reasons actually set forth in the act that an employee would qualify for this additional unemployment compensation. But what it's going to do, it's going to provide 13 additional weeks of unemployment. In Virginia, the maximum amount of weeks you can get as a benefit is 26 weeks. This is going to give someone 39 weeks, provided they fall within the entitlement somehow relating to COVID-19. Additionally, for 4 months, that employee is going to get $600 per week in additional pay. And this is only if the state in which the employee is working has reached an agreement with the federal government, and will get all kinds of tax incentives and other things to reach that agreement. The federal government will then reimburse the employer the entire amount of, or reimburse the state, who I guess those benefits will trickle back down, the entire amount of that extra $600 per week additional pay, as well as the 13 additional weeks of unemployment. And so we're still kind of seeing how that plays out. Again, we don't have any regulations interpreting it, but it does look like there's going to be an extra benefit for employees who are out of work and not on the paid leave, FMLA leave, that kind of thing. So if you are on one of those other types of leave that we talked about earlier, you are not going to be eligible for unemployment compensation. That would kick in after that. Paul, you want to finish up with some CARES Act, and then we'll take some questions?
Yeah, and yes, I'll finish up with the 800-page legislation in a matter of minutes here. So I was talking to one of my partners this morning. Our firm obviously has a number of business lawyers. Cate and I, our primary area is employment law and litigation within that. But this CARES Act is obviously, it's a beast of a law in the sense that it's so lengthy and has so many details. I think our initial advice to our clients right now and to companies in general is you might want to hit the pause button before you make decisions on how you're going to deal with your workforce, whether you're going to keep them on payroll, whether you're going to lay off, because obviously the CARES Act, and you've heard it through the media, what it has in terms of this forgiveness of a loan for small business administration loans up to, I guess it's $10 million, and then it's a reimbursement type thing, and then where it's actually going to act like a grant for some of these loans. But I've been told from people that have read it far more in detail than I have that, the devil is in the details of this thing. The devil is in the details of this, excuse me, because there's a lot here to digest and figure out what is best for a company. So you've got all these things kind of working together, whether it is under the CARES Act for the extended unemployment. You've got the reimbursement issue with the loans that could be very helpful, obviously, particularly if it is treated like a grant. But how does that really look and how does that work out? And then you have the tax credits. And I think what we're telling people right now is we need to see to make sure that the House, and maybe it's happened right while we're all listening in on this, but we need to see what happens with that and then digest that. I think we're probably going to be doing, our firm and others, and it's very great to have labor finders doing this, and maybe we'll be able to set up something. I'm sure labor finders will be able to do that next week on the CARES Act to give you a little more detail. I think in the meantime, the best advice I would give on this law is to start learning about it through either your legal counsel or your accountant. And quite honestly, since accountants are so busy, and I realize there's an extension on tax day, but would be scheduling as soon as possible with your company's accountant time to meet and go over this and what is going to be the best plan for you as a company, whether that is, bringing people back in. I mean, I've heard the advice is, listen, if you've laid off a bunch of people, it may be to your benefit to put them back on the payroll for the next 12 weeks. We'll see. I don't know all the details yet, but I think there's a lot of opportunity here for companies of certain sizes to take a look at it and decide whether this is going to fit them or not. Cate, anything else on your end?
I don't think so. I think we can take some questions. Stuart, do you want to kind of moderate and ask what you'd like us to answer?
Sure. So what we'll do, I know there's quite a few questions in the queue, and we had quite a few questions that were submitted in advance. So we'll try to tackle the ones that were submitted in advance first, and then we'll go down the list. And I think first is, if an employee is sent home by an employer as preventative precautions following CDC guidelines, will these be considered an isolation order?
Oh, okay, I'll hit this one. No, I think the answer is no. And again, it's hard to know this question out of context. But that, again, the isolation orders are, look at it from, at least under the law that we've been talking about that was passed last week, look at it from the employee's perspective. So if an employee is sent home by its employer as a preventative precaution, just following CDC guidelines, that does not mean that they have somehow been sent home by an isolation order or something like that. Now, obviously you have to look at each state, but in our opinion, that itself will not qualify. Cate, any different thought on that?
I was muted. No, I think you hit the nail on the head with that one.
Okay. So along those same lines, if the state has issued a shelter-at-home order, but it does not apply to essential businesses, if the employee is sent home for COVID reasons, would it then apply?
Again, I think the answer would be no, because again, under this law, as we understand, we don't have the regulations. It is looking at what the employee, this is, you look at the very core of the law, and as a lawyer, I read this law is meant to provide emergency leave and FMLA extended. How, and you look at those 6 qualifying reasons, if the employee has been ordered to, that they have to stay at home because of something that qualifies under those reasons, then I think that's a different situation. But just the fact that the state has issued a stay-at-home rule or something like that, this one's a little closer, and until we get the regulations, but I still maintain that at least the law that we're interpreting right now, dealing with the emergency leave and extended leave, looks to what the employee's reason is for being out.
Okay. If an employee is sent home for presenting symptoms and returns to work with a doctor's fit for duty form, but still presenting symptoms, can the employer still send the person home?
Absolutely. Listen, that's, you could have done that before all this happened, and I don't see any reason why you couldn't. you know, I would much rather deal with whatever complaint they may have about that. But if just because they've got a fitness for duty form, if they are still presenting symptoms, the employer has the absolute right to say, listen, when you are symptom free, and in our you know, reasonable belief you are or are not, at this point, you know, I mean, you see somebody coming in, they're not symptom free, I have no problems with them being sent home.
Okay. So next one is, the emergency sick leave states that it becomes in effect April 1st. Our employees are paid in arrears. Therefore, hours worked 323 to 327 will be funded on April 3rd. Would the tax credit apply in this case?
I think the tax credit will apply beginning April 1st. I don't think this is not a retroactive law, so it should be from April 1st going forward.
For time taken beginning April 1st?
Yes.
Okay. Do you have any information regarding the rules being changed to allow independent contractors and those self-employed eligible to receive benefits for unemployment? I think the answer under the new act is that it is coming for independents.
That's right. It's coming for your 1099 folks. It's coming for self-employed people, part-time workers, as well as a very broad emergency unemployment compensation law. You still have to meet the eligibility requirements for it and apply for it and all that, but it will cover these other folks as well.
Okay. Do you have any information regarding how the unemployment benefits and any of these other benefits apply to companies that employ union workers?
Yeah, I spoke with one of our labor lawyers who focuses heavily on labor about this issue. And from his perspective, and he's looked at this thoroughly, he said, right now, they're not seeing any different, you know, it's kind of business as usual in terms of how it is and issues dealing with the union right now. Unions are generally going to continue the way they have been and deferring obviously to the collective bargaining agreement and obviously the relationship with the union reps and dealing with that. So he does not see anything right now that he has seen in either the guidance. Again, we'll wait for the regulations to come out to see if there's anything, but nothing so far.
Okay. Regarding the calculation of a small business with under 50 employees, if you employed, for example, 30 people at a time, but over the course of the year, you may have ramped up beyond 50, are you still considered under 50? And I guess essentially, when does that, what's the measurement period, or when does it apply?
So again, we don't have the regulations, which we're really hoping can give us that answer. If you look at general FMLA, they're going to look back over the past year or the past FMLA period to see if you had any employees over the threshold during that time frame, and they're going to count from there. So if you're fluctuating between 40 and 60 employees, then you're probably going to fall within the 50 or more. Now, again, the under 50 employees only gives you the option to potentially apply for an exemption from the paid sick leave and paid emergency FMLA. And again, we don't know what is going to qualify for someone for that exemption. So it might be that you have 50 or fewer employees. It won't matter if you fluctuate because you're not getting the exemption anyway. So again, that remains to be seen with the regulations.
Okay. Moving to the ones that were submitted during the call. So if the layoff was before 4/1 and they are already laid off, would they be eligible?
The answer to that is going to be no, because they are not somebody who is, and I assume we're talking about the paid sick leave, paid FMLA. If they're already not working, then they're not going to be eligible for a paid sick leave or a family medical leave because they're already laid off and not working.
Okay, and I do recall you guys mentioned that you need to be careful about making those decisions just prior to 4/1 to make sure that there's no retaliation issues and things like that. Is that correct?
That's right. If you are about to lay somebody off because you know, oh, that person's got a child at home and I'm going to have to cover them under this new emergency FMLA, or the person has come and inquired to you about the new law and you immediately respond by laying them off, then you might be opening yourself up to a retaliation claim.
Okay. Do all of these, as far as you know, apply to nonprofit organizations as well?
Yes, we haven't heard anything that they do not. I mean, they're again, it's interesting. I was reading an article about that because we've got a number of nonprofits that we represent. I've not seen anything that changes that dynamic, but maybe that may be something that's been overlooked, and there could be some changes, and well, let's see what the regs say, but I haven't seen anything yet.
I expect there's probably some benefit for nonprofits within the CARES Act. Again, I don't know what they are, but under the FMLA and the paid sick leave, that's if you are an employer who offers FMLA, if you're an employer who's going to be within that 500 or fewer, then you're probably going to be subjected to the same requirements there.
Okay. If we send a person home to self-quarantine because they've been exposed to a positive person, can we ask them to use the mandated leave that is given since it is the employer asking them to self-quarantine?
I would say, yeah. So the answer to that is yes. If somebody's exhibiting symptoms and you, the employer, are sending them home, then that would be something that would be eligible for that paid sick leave. Now, because this is emergency leave, you cannot first ask, and I don't know if this is exactly the question, but you cannot first ask that employee to use any accrued leave they already have. They're automatically going to be eligible for that paid sick leave time because they've been sent home for symptoms related to COVID-19.
So how are you interpreting that for prior to 4/1?
Prior to 4/1, that person is not going to be eligible for those benefits. If somebody is out starting, let's just say last Monday, and they are out through 4/1, then they're going to get the pay for 4/1 only. It is not a retroactive law. Even if they're out days prior, or if they're receiving, if the employer is giving them FMLA for that, then the new paid leave and paid FMLA will not kick in until April 1st, regardless.
Okay. So this was submitted early on in the presentation. I don't know what slide, but it basically said that your number 6 was different than the DOL poster. And there was a question about whether there was a revision or whether that was the federal one. So I don't know if you guys know off the top which slide that's referencing.
Hold on, I'll find it.
All right, well, we'll come back to that.
Yeah, come back to that one.
Okay. How many times can one employee be out for 80 hours? Example, home taking care of affected family member comes back to work after and then comes down with the virus. Is that another paid 80 hours?
No, the answer is they only get it once.
Okay. Can both parents take the leave for the care of a child at home?
If the employer is a sucker. Now, I would think that would be some of the documentation you would ask the person to provide if they are the only caregiver, or if somehow they can split. Now, you may see a situation where both parents or both folks who are caring for the child at home want to take some intermittent FMLA leave, or one person takes, Monday, Wednesday, Friday, the other does Tuesday, Thursday. That's going to have to be something you work out with the employee. And again, you are allowed to request documentation to show that.
Okay. Regarding the emergency FMLA, what if the job or department the employee works in was all laid off during the time they are out? So I take that as during the time span that somebody is out under the FMLA and you make the decision to lay off all employees, does that change the status of the employee?
I believe it does, actually. If you look at these new guidance questions, I think it does. I think at that point, because it's just like normal FMLA is, if the operation shut down, then there's nothing left to protect. And so I would think they would then be looking at going and getting unemployment.
Okay. Question is written, if I understand, an employee with less than 30 days employment prior to 4/1 is allowed up to the 80 hours, but not the emergency FMLA. What happens if that 80 hours pushes them over 30 days? Are they then eligible for the emergency FMLA?
Yes, the question is going to be whether the person's on your payroll. So at that point, if they're receiving the paid sick leave act, that person does constitute an employee if they have not actually worked the equivalent of a full 30 days.
What is the required post date for the poster?
April 1st.
Okay. Is county mandated closing of a business covered under 1 through 6? I again believe that refers back to the slide that you were just looking for. And is that interpreted as number 6, experiencing any other similar conditions specified by the U.S. Department of HHS? We are essential as construction. Are we still looking for that slide?
I found the slide. So what the Department of Labor poster says, number 6, is experiencing any other substantially similar condition specified by the U.S. Department of Health and Human Services. We just expanded that a little bit. Health and Human Services has consulted with the Department of Labor and with the Treasury Department to determine who's eligible and for what regarding this paid leave. So it's going to be the type of substantially similar condition that is specified by Health or Human Services. And again, each of these laws has kind of a little catch-all provision in case they forgot something. This is the catch-all provision under the paid sick leave. We're hoping for a little more guidance on that under the regs, but right now we just have to look to whether the Department of Health and Human Services has defined what may or may not constitute a substantially similar condition to someone who has COVID-19 or is required to care for somebody who's been diagnosed with COVID-19. And to answer the person's question, I think they were talking about if a county has specifically ordered isolation or ordered certain businesses are essential or non-essential. Again, that person's not going to fall under paid sick leave or emergency family medical leave unless that person is actually in some sort of quarantine or isolation order. Otherwise, they would just be eligible to apply for unemployment.
Okay. So we've been asked by multiple people if we'll be sending out the slides or they'll have access. The answer is absolutely yes. The surest way to get it is to send me an email directly at Stuart, that's STUART .Dukeman, DUKEMAN @laborfinders.com, and I'll be happy to send you the slide. And then we also will do our best to make a recording of this available by later this afternoon. Next question, can you please repeat what Paul mentioned regarding paying employees when a business is forced to close due to a county mandate? So I think that would apply to non-essential businesses that were forced to close.
I think Cate just addressed that one on the county mandate. Am I correct, Cate?
Yeah, so just because some sort of government, federal, state, or local has ordered certain companies to close, that does not necessarily mean the employee is going to fall within the paid sick leave or emergency FMLA. They would be eligible to apply potentially for unemployment compensation.
Okay.
Yeah, I think until we're told differently from regulation standpoint, I just keep on beating this drum. This law that we're talking about, the emergency leave and the extended family leave, really are looking at it from the perspective of the employee and why that employee, this was intended, I believe, to deal with employees that were suddenly found themselves at home having to care for their children or somebody else, or were sick or demonstrating illness issues, or that had been specifically told that they are being quarantined, because of something that happened, not about their employer, but about them individually, and that's where I think that law really is emanating from. That is the angle. Having said that, it has obviously created a lot of uncertainty in that and then the only reason we're getting more certain on it is if you look at the questions and answers from the Department of Labor, again, virtually all of them are from the angle of, well, if the employee has this, the employee has that. And so that's why I think I continue to believe that is the way it's going to come out even in the regs. If I end up being wrong, I'm going to be wrong on this one.
Okay. And this one you did address. The question was, can an employer reduce employee hours and rate of pay during the pandemic? And the answer was yes, but clearly you made a distinction between non-exempt and exempt employees and how that needs to be handled. So again, we'll be emailing out the presentation. The answers are on that slide, and you can always follow up if you have additional questions. If you send an employee home because they are sick, do you have to pay them? Again, that's pretty much the crux of this entire webinar, so that's covered. Can we see the link for the FMLA poster that Cate was mentioning? Again, we'll send out the presentation. It'll be in there. I think also we can have Cate copy and paste that to the chat to all members, and you can copy it from there. If we reduce or cut our part-time employees' hours but still keep them employed, can they file for unemployment?
Yes, generally in the particular state, you can have partial unemployment, and I think the CARES Act is taking a lot of steps to address this as well. But if the question is whether they have partially reduced hours, most states are going to permit them to seek unemployment on a temporary basis.
Okay. And we also believe that unemployment is going to apply to 1099 workers as well.
Correct.
Yep. Okay. How do you define if someone is qualified as a caregiver, or if their kids are home from school and they need to care for them, if they have a spouse that could be watching the children? How is it determined so both parents don't apply for the status? And I think, Kate, you addressed that in an earlier question.
Yes, that's right.
So actually, he just clarified, and he's asking, can you ask for proof that the spouse isn't also claiming the same leave?
Right now, we don't know. We don't know exactly what proof you can ask for. We do know you can ask for some kind of documentation to show the daycare center is closed, to show that the school is closed. That could be as simple as a news story saying, Governor Northam has issued a closure for K through 12 schools, something like that. The degree and detail to which you can get information, I am hoping is going to come out in the regulations. Right now, I think the best test for an employer is to go with your gut and be reasonable in what you ask the employee. You don't want to ask them questions that is going to make it look like you are planning to retaliate against them because you perceive they may not be telling the truth. Just engage in a conversation with the employee about, are there any other care options? Are you the primary caregiver? Things like that, and you should be okay. And then document those conversations.
Yeah, I think Kate hit it right on the head. I mean, this is an area that, you know that 99% of your workforces will not be an issue, but it'll be that one small percentage that takes up all your time and effort, and where somebody you feel is either taking advantage of the system one way or the other. I think if you look at the most recent question and answers that just came out, they're getting closer to giving you information as to what you can ask an employee. May not have that direct point that you just asked about, but I think Kate's right that, this to me is one where, ask the information, just be reasonable about it. And then you're gonna have to use your own spidey sense, as they say, as to whether or not you believe in them. So.
Okay. So Paul, in your presentation, you referenced the ability to reduce a salaried employee's income to not less than $684. Are you also able to reduce an hourly rate for non-exempt employees?
You can reduce them down, take them down to minimum wage. I mean, if they may not be happy about it, but yeah, you have the absolute right. Listen, every state could be a little different, but generally, if you have the right to terminate somebody, you have the right to reduce their pay. So to me, I don't see any difference in that. For the non-exempt employees, they just got to be paid minimum wage of that particular state.
Okay. We had an employee call out for a day off because their spouse had a fever and they needed to watch their children. We then required that employee to work from home for an additional 3 days after their spouse was fever-free as a precaution. What requirements in terms of pay are we required to give the employee? I guess the answer to that may depend on whether they're a salary exempt employee versus a non-exempt employee, correct?
Yes, that is one thing. So if they're salaried, then if that person works even a little bit during that week, you're gonna have to pay them for that week of work. Obviously, if they're not exempt, you're going to pay them for the time actually worked. Under the new laws, that person, it sounds like, if they have a spouse who is out for 1 day and they're caring for the child, then they may qualify for the 1 day of the emergency FMLA leave. And then the other 3 days, if the employer is basically asking them to self-quarantine because of exposure they had, that may fall under the paid sick leave.
Okay. Are there any FMLA forms that we typically use still required?
That's a good question. I wish that we had sample forms. We don't have them yet from the Department of Labor. It is covered a little bit in the new guidance. I'm trying to find where it is because it specifically talks about some of the certification forms. But obviously, you're not going to have a physician signing off and then every 30 days. It's going to be a little different because the only reason you can get this FMLA leave is if you're caring for a child or for an elderly parent or someone who is generally in the care of someone else during the day. So I assume there will be some sort of modified forms for folks to use. We just don't have them yet. Right now, I would encourage you to, if you can somehow modify the forms you already use to get that information, or just draft something, some kind of letter requesting the employee provide you how long and the reason that they're taking care of the child, all those things. Because again, I don't think your standard certification forms are going to work.
Okay. I'm not sure whether this comes into play or not, but someone asked if you could address the short time compensation program with the DEO.
I don't know. I do not know that one. I don't know.
Okay.
Sorry.
I see Kate doing a little quick search there, so we'll let her get to that. All right, so some of these were posted in a different spot. I will repeat my email address in just a few minutes when we close so that we can make sure everybody who wants a copy gets a copy. Look here.
Yeah, so this is another aspect of the CARES Act. It's not something I've gotten to yet. Again, we are drinking through a fire hose, especially with the CARES Act, because it's over 800 pages long. But that is something I expect we'll be able to provide a little more insight into after it's actually passed into law and we start to get some guidance on how it's implemented.
Is your understanding of the unemployment additional pay of $600 for everyone, or is that the max benefit now or added to current max benefit of Virginia 378?
So it's only going to be for folks who are eligible. It has to be, and there's a list, I think it goes AA through KK or something like that in the CARES Act showing who would qualify. The person obviously has to be unable to work or telework for compensation due to one of the reasons related to COVID-19 in the CARES Act, and we can provide you those if you'd like. The answer is that it is in addition to your weekly benefit. So if you are receiving the max weekly benefit, it's going to be $600 in addition to that for 4 weeks, or I'm sorry, for 4 months.
Okay. And can you recommend the website that people can go to for defined guidelines for the upcoming SBA loan and repayment information? Does that even exist yet?
No, not yet. I'm sure our law firm is going to come out with some guidance on and that website's www.gentrylock.com. But again, it's so new. I don't think there's any one website that'll give you everything you need to know in bullet point format yet.
Okay. I think the question is, if we apply for SBA loans, will they look if we have other available options to utilize, say, our line of credit and approve or deny them accordingly? I think that's still a little bit unknown, but my understanding is that there's not an exhaustive effort that you must utilize other lines first. It's just whatever is best for your business.
That's what I've heard as well. And I don't want to speak out of school, but I'd heard the same thing.
Okay. We have 21 employees. They wanted to know if they're responsible for paying FMLA. Sounds like they'd have the exemption.
Well, we don't know. I think some small businesses would be eligible for that exemption. They have to be able to show that it would affect the viability of their business as a whole. So they may. Unfortunately, I know that's not very helpful. We would love to have more defined regulations and guidance as to how an employer would apply for that exemption. I'm not entirely sure that the Department of Labor knows how that's going to work yet. So the answer is, unfortunately, it depends.
Okay. Question is there a standard document that we can find online to help create the language that notifies our employees that are laid off until further notice? Has your firm put out any suggested letters or wording for layoffs?
We actually have, I just saw one letter went out last night. I know we helped within a company with a layoff and outlining, here's what you can do, here's what we're going to do in terms of healthcare insurance. We could certainly, I might be able to take that letter, redact it, and post it along with, maybe give it to you, Stuart, and at least somebody can see that's one form. We'd be happy to do that.
Okay. And what is the likelihood of being sued by an employee if they catch COVID-19 and we are a manufacturer deemed to be open?
Okay, well, I've dealt with that question this morning. I don't see a high risk unless you have really breached your duty of care. And again, this would be state specific, but even under OSHA, and I'll let Kate chime in as well on this. You would have to, I mean, that's the thing. You would have to be incredibly negligent. And even then, the fact that somebody caught it just because you remained open, I don't know of any law that would trigger that you have an obligation other than under OSHA, you created an unsafe work environment. So if you created an unsafe work environment and you knew it and you still made people come in there and you had COVID there, yeah, you could absolutely trigger an OSHA type claim where you could be investigated on that, just like you would with any other unsafe environment. But again, it would depend on how far down that road you had gone in terms of, okay, just the fact that maybe somebody tested positive and then somebody goes in there and gets it. That's very different than, hey, we know we've had a group of people test positive, but who cares? We're going to stay open and, screw you all. This is just the way it is. And you have to come to work. So that's a whole different animal. I don't know, Kate, if you have anything more to chime in on that.
I mean, what is the likelihood of somebody suing or successfully suing? I mean, people sue for stuff they don't win on all the time, right? So I could see this playing out if somebody's filing workers' comp claims, which is technically suing their employer, OSHA, that kind of thing. But then I agree with what Paul said. It's going to be really hard to prove unless the employer was basically just completely reckless in how they handled it.
With respect to part-time employees and the 30 calendar days, do you interpret it as days worked or 30 calendar days from first day of work?
Again, it's how long they've been employed with the employer. So if I am employed as of April 1 and I've only worked 2 weeks, I've been on the payroll since April 1. And so they're counting it as 30 calendar days.
Okay. Let me just see, I think we had, what is an employer's responsibility to an employee who is not currently ill, showing symptoms, etc., but is so nervous about getting the illness that they don't want to be in the office? Some of their job can be done from home, some cannot. We are an essential business providing mitigation for the illness. The employee is salaried. It's a really good question because I think it applies to a lot of us.
Yeah, it's good. And I think both Kate and I can give our bit on that. We have had that. So if you look at the guidance clearly states that just because you're fearful of working or don't want to work, that is not going to get you, it's not going to get you qualified under one of these emergency leaves. And then the employer actually could terminate your employment. Again, you have to look at the different state laws and terminate you for not showing up for work or whatever. And, you would then, I guess in theory, then could pursue unemployment. You may or may not get it, depending on if you because if the work's available and the person's not working, right now there's nothing in there in any of the guidance we're seeing. In fact, just the opposite, that if an employee says, hey, I'm not going to work because I'm afraid of catching the virus, or for whatever reason, that's not a stated reason to allow you not to work. Again, if a person's like going to work some of the time, work telecommute some of the time, but they don't come in all the time, that's a performance issue from my perspective. And obviously if they are exempt and they're working part of the time, you're gonna have to pay them full time anyways because they're working part of the work week. Kate, what do you think about that?
Yes, I think that's key with what Paul said. If the person is salaried exempt and they're only working part-time from home, you're going to have to pay them for the entire time. If they're non-exempt, then you pay them for the time worked. Now, under the OSHA regulations, if an employee has a reasonable belief that he or she will be subjected to imminent harm if they do come into the workplace, and you tell them you're coming in anyway, then they could sue you for retaliation under OSHA. Now, what is a reasonable belief? What is not? If you have a generally kind of well person who's, say, 30 years old, and they say, look, I've read the news, I'm scared, I'm not coming in. You've had nobody with symptoms in your workplace, no reason to believe there's any threat of harm in your workplace, then there's going to be, there probably will not be a reasonable belief of a threat of imminent harm for that person. Now, if you've got an older worker who you are aware has a respiratory issue or a heart condition or something that may put them at higher risk, and they're very fearful about coming in and working, let's say your business was an essential business providing mitigation for the illness. If they are exposed to the public, if they're exposed to folks who've traveled recently, that might be a reasonable fear. And you may want to work with that person and not have them come in, maybe have them, reduce their salary and have them work from home. But that's just going to be an analysis that you have to work through with the employee to show whether or not that is some reasonable fear of imminent harm.
And we've had even questions come in from dental practices, as if you look at the rankings of the highest risk position there is a hygienist. And there have been situations where we got them last week where the dental practice wants to remain open or has to be open for emergency procedures. What do we do? We have a hygienist who doesn't want to work. There are not clear-cut answers on this, just as Cate said. So that one's, we love it. We all want the, clear-cut answers, but these are fact specific, and you gotta look at the different circumstances.
All right, last question. If an hourly employee is immunocompromised and has doctor's notes stating as such and wants to self-isolate for precautions, does the employer have to pay them?
So what was the first part of that question?
If an hourly employee has an immunocompromised condition and has a doctor's note, I guess the answer is they would potentially qualify under one of the leave acts, maybe, right?
Yeah, they may qualify for paid leave. One, it would depend on what the doctor's note says. If the doctor's note just says this person is immunocompromised, then there may be other things that the employer can do, separate them out, put them in another place to work for a while where they're not going to be around others if there's not a threat. It kind of goes back to the OSHA example I gave before. Now, if the doctor says this person is immunocompromised, I recommend this person quarantine for 14 days, and they may be more inclined to be subject to the Paid Leave Act. But that's something that's going to be on a case-by-case basis and might require a little more of the interactive process with the employee.
Do you see that as being a potential ADA related issue?
It could. Mm-hmm. Yeah, it could. And so that's the problem with this stuff is, whether COVID-19 would be considered a disability under the ADA, I doubt it. But somebody who is immunocompromised, would that be considered a disability under the ADA? Probably. And so you're going to have to engage in the interactive process with the employee. If the doctor's note doesn't say you should self-isolate, maybe putting them on that paid leave and sending them home for that reasonable, 2-week period may be the accommodation you're supposed to give them. Again, it's just going to be that same analysis as you would with somebody else who has a disability qualifying condition under the ADA.
Okay. All right, guys, I think we're going to wrap it up here. I believe everybody can see the email addresses on the screen. We will make available the presentation. Also, the recording will be available this afternoon. I will try to get that uploaded and provide a link to rewatch the recording. We'll coordinate with Cate and Paul to possibly try to do this again, maybe next Friday at the same time, once they've had a chance to digest the new information that's coming out for the CARES Act and some of the guidance that may come out. And we'll be sure to let everybody know and make it available. So Cate, Paul, appreciate it very much. Obviously very useful information and much needed these days.
Thanks for having us.
Thank you, guys.
Stay well.